So continuing with, we're going to focus on common law or the case law, and it's created by the judicial branch through court decisions. Remember the idea of setting precedent. Based on precedent, courts look at earlier cases and look at the patterns and sort of follow it there. So here the scope is pretty narrow and it's limited to real disputes that come before the courts. They're fairly insulated, so judges are somewhat shielded from direct political pressures, though they're not entirely immune from them. And then there's also an important doctrine of stare decisis. So it's like let the decision stand, where courts follow precedent for stability and predictability. So it reflects like judicial modesty and humility, so it avoids constant change. But it's not absolute, as courts can overturn precedent if it's justified. So there are two types of authorities as well. There's mandatory authority and persuasive authority. So this is going more into the idea of precedent, where mandatory authority is binding decisions from higher courts in the appellate chain. So the trial court must follow appellate court rulings. So everyone follows like the Supreme Court, and then anything underneath has to follow whatever the higher court says. So that's like mandatory authority. But then in the case that there's no decision from other jurisdictions or from like the higher courts, the persuasive authority comes into play, where decisions from other lower courts or other jurisdictions, the judges may find them persuasive, but they're not bound to it. So they can use it as precedent. They can see the court over there, like they make a ruling on that, and then they accept that as well. If the two precedents like contradict, a judge can choose the one that's more reasonable in their case, or they can create an entirely new solution. So this really shows the flexibility of the law as well. So there's a good case example on how courts can like overrule and overturn precedent. So thinking about the idea of abortion. So we have Roe v. Wade and Planned Parenthood versus Casey. So here, in these two cases, abortion was protected. There were numerous other cases that also compounded on this and protected abortion like laws, right? And then you see Dobbs versus Jackson Women's Health in 2022, which basically overruled Roe and Casey, allowing states to ban abortion. So there are some things, there are factors that are to be considered with stare decisis. So first one would be workability. Is the rule clear and consistently applicable? Like Roe v. Wade, in this case, it was workable. Number two is, what are the effects on other areas of the law? The third one is reliance interest. So do people depend on the precedent in planning their lives? So for like Roe and for Casey, people did. And then the fourth one is institutional legitimacy. So they should be guided by principle and not politics. But despite these factors, like keeping these four factors were not really, when they considered that in the overruling of Roe and Casey, they should have kept it, but the majority overruled it, claiming that it was like egregiously wrong. Basically, like the court said that abortion laws are valid if they have a rational basis tied to state interests, like in their words, they quoted maternal health, protecting fetal life, things like that. The criticism here would be that it weakens stare decisis, where it undermines legal stability and institutional trust. Going over to the second part, so we just talked about common law, setting precedents, that sort of thing. Let's go to statutory law, which is created by the legislative branch through formal lawmaking of bills. So think codified written laws and statutes. Bills go into statutes. So codified text has a broader scope, right? And it applies generally, not case by case, as I mentioned before. It's subject only to constitutional limitations, meaning that statutes can't violate the Constitution. Thinking about free speech protections, due process rights. It's also directly shaped by political and social forces. So the elected officials respond to constituencies. So the statutory law is necessary. It's important. And the legislator's primary role here is in structuring government and regulating activities. So the common law cannot regulate everything. Think about criminal law. People need to know what acts in advance are like punishable. So that's why criminal law would follow under the legislative statutory law, and statutory law can override or reform common law. It also responds to new social and technological problems where there's no precedent. No precedent exists. Since the world is ever changing, law is also changing. That was one of the pillars of law in terms of like adaptability and reliability. So the next thing is limitations on legislators. So there are procedural requirements. They often require there are like three main things: the no special laws for only some citizens. It has to apply to everyone. And then subject of every act must be in its title, and no bill with multiple unrelated subjects. So this prevents surprise laws and like bad bills, basically. So there's also the requirement of certainty. The laws must be clear and not vague. So contrasting statutory law and common law. Right, we went through both of those individually. Now let's go into a more divisive, what's the difference, right? So let's talk about the aspect of process first. You see, common law is made by judges in case decisions, and then the second one, the statutory law, is made by legislature via formal processes, like turning a bill into a law. And then the second thing after process, we'll look at scope. So here, common law, it's more narrow, more case-specific, since the idea of precedent, right? And then statutory law is broad, it applies generally. And then the influence of politics is another difference between them. Here, judges in common law are fairly insulated to the influence of politics and social pressures, whereas in statutory law, it's highly influenced by political and social forces. Think about who owns, like, Republican versus Democrat, who owns the majority rule, right? And then flexibility is another thing. So for common law, it evolves case by case. Precedent keeps, it goes case by case. And the statutory law, it can regulate new areas, and it's sort of the overarching law theme. So some example of common law, you can think of property rules, contracts, and then statutory law, think of criminal law, tax law. Okay, so let's now talk about statutory interpretation. This is also really important as well. So here, courts need to decide what a statute means when it is applied to a specific case. So there's the plain meaning rule, where you really start with the text. If the words are clear, you apply them. But of course, words and languages are hard. So there are two types of canons. You have linguistic canons and substantive canons. Starting with linguistic canons, you think about the rules of grammar and context. There are like three terms. I'm going to be totally butchering these, but you have nocitur associis, which is like a word is understood by the company it keeps. So really think of context as a whole. And then there's another one where it's the expressio unius, which is if a law lists, it prohibits A, B, and C, but it doesn't say D, then it's just you assume that it doesn't mean to exclude D. So D is okay, it's not really prohibited. And then the last one is like general terms limited by the specific ones listed, which is the one that I just said. Okay, and then substantive canons, you're thinking about statutes should not be retroactive, and they're presumed to be domestic. So why do we need to go beyond the text, right? Why can't we just take the plain meaning rule and just read the words? Well, that's because drafting is pretty imprecise whenever they're talking about new statutes. There's deliberate vagueness. Oftentimes the wording is due to a compromise, so there's going to be lack of clarity there, and there's also political language and tensions within the room whenever they are writing the statute. Language itself is imperfect as well, and these are written by humans, so there's going to be little intricacies that are, you have to interpret that differently. So then, and words can't always capture the real complex realities. So there are also different types of extra textual aids that you can use to go beyond the text, thinking circumstances around the passage, legislative history, thinking about verbatim committee reports, debates, things like that. So an example of when we had to really interpret statutes, this case example of Yates versus the United States. So Yates was this fisherman guy, and he caught a fish, and he ordered the fish to be thrown overboard and he was convicted under statute of punishing destruction of a tangible object. So the government argued that the fish is a tangible object, but in the statute it says that, Yates argued that the statute only meant records and documents to be tangible objects, and like a fish is not a tangible object. So this is where wording really matters, and that's where they were really arguing about the wording. So the court used the canon that since tangible object was listed within a list of record and document, it should be read in that context, and a fish is not included in that. So that's really the bulk of the first lesson of business law. Let me know if you guys have any questions, and I'll be out with a new video on what else I'm learning in class.